immigrationquestion.com, your go-to resource for U.S. immigration insights. We provide clear immigration news and information. Our platform provides a network of licensed attorneys who can answer your questions and guide you through the process. From visas to green cards, asylums to citizenships, immigrationquestion.com helps you to network with immigration attorneys so that you can move forward with confidence. Sign up today or download the app. Free registration, limited time offer. Stay tuned. We go live in 30 seconds.
Hello everyone and welcome to today's live webinar brought to you by immigrationquestion.com, a networking platform and meeting ground where immigrants, families, and professionals and licensed immigration attorneys come together to learn, exchange information, and stay current on U.S. immigration developments. I'm GB Satusa and I'll be your host for today's session. H-1B survival and backup plans. Cap rules, transfers, and cap-exempt employers. The H-1B visa process remains one of the most discussed and closely watched employment-based pathways in the United States. With annual numerical limits, lottery selection procedures, strict filing windows, and evolving adjudication trends, many professionals and employers face uncertainty at multiple stages. When petitions are not selected, delayed, or employment circumstances change, understanding available options becomes essential to maintaining lawful status and career momentum. Today's webinar is designed to provide a comprehensive overview of H-1B survival strategies. We'll examine how the CAP system works, when transfers are possible, how CAP-exempt employers operate, and backup plans may help professionals avoid gaps in status while planning for both immediate and long-term immigration goals. To guide us through this important topic, we are joined by Tiffney Johnson, Esquire. She is an Arizona-based immigration attorney and founder of Tiffney Johnson Law. With over 15 years of experience, she advises individuals, families, and businesses navigating complex employment-based immigration processes, including H-1B petitions, transfers, and long-term strategic planning. Attorney Johnson, thank you for joining us today.
Thanks for having me.
Now, before we begin, a quick note for everyone tuning in. immigrationquestion.com is a public platform created for networking, education, and discussion. Attorneys who participate do so independently, and the platform does not provide individualized legal guidance. To everyone joining us from Facebook, YouTube, LinkedIn, and other platforms, welcome. If this is your first time, welcome. If you haven't subscribed yet, now's a great time to do so. Grab your notepads and let's get started. A good place to start will be the H-1B cap itself. Now, Attorney Johnson, the H-1B cap continues to create uncertainty for many professionals. Can you walk us through how the cap process works today and what applicants should realistically expect in 2026?
Okay, so the H-1B cap refers to the number of new H-1B petitions that can be approved each year that are not filed by cap-exempt employers, which is a concept I think we're going to discuss a little later in the stream. And so if you're a new H-1B applicant this is actually called the fiscal year 2027 lottery, the employer will have to enter every person into the lottery between the open period of March 4th and March 19th using the USCIS designated platform. As in prior years, there will be 20,000 advanced degree selections, 65,000 standard selections. But this year, the difference is that all the standards will be weighted, meaning that employers willing to pay a level 4 wage will receive 4 weighted entries, 3 for level 3, and so on and so on. Those aren't actual entries, but it's a weighted chance in the way the algorithm is done. And so this applies to both selections, the advanced degree selections and the other selections. But you also have to keep in mind a level 4 wage that's different by profession. So what that means for somebody who's a physician is totally different from an accountant. And those are all designated by the Department of Labor. So then if the selection is for somebody who's not in the United States, and doesn't have the eligibility to change status, the other under the current policy is that the employer will have to pay the $100,000 fee if they actually end up filing a petition based on that lottery selection.
All right. Now, for individuals who are not selected in the H-1B lottery, what backup immigration options should be evaluated immediately to reduce the risk of falling out of status?
Okay, so because, as I mentioned, this year, the $100,000 fee will apply to new H-1Bs that are not eligible to change status from something else to the H-1B, many of the entrants will be people here in other statuses like students. Therefore, for the vast majority of people who don't get selected in the lottery, the quickest thing to do is to enroll in another program for the fall semester, something that makes sense for your educational trajectory. If you've already graduated, you may still have your OPT option, your STEM OPT options. You might have the option for a J-1 postdoc program. These are all things that are pretty seamless transitions from a student visa. Of course, with the J-1, you have to be careful that you don't have a requirement to go back to your home country after the program. There are other options that some people might qualify for, such as the O-1, which is a work visa for people with extraordinary ability, or E-2, which is an investor type of visa. But these aren't quick options. They will usually take time and planning.
Now, H-1B transfers are often seen as straightforward, yet complications arise. What common mistakes or timing issues do you see when employees change employers?
Yeah, I would say now more than ever, we are definitely starting to see that transfers are not as straightforward as they used to be. USCIS has put much more scrutiny on what's called the grace period, which is the 60 days that you can lapse between your transfers. If you lose your job, quit your job, or something happens with your employment. But this 60 days is actually discretionary. So it's always been that way, but now that level of the discretionary part is actually part of the adjudication. So unlike in the past, you now need to specifically ask for the grace period, for the discretionary grace period to be granted. And you have to provide documentation that you were actually laid off or left your job in the 60-day period if you're not still employed with that previous employer. And I've also started to see USCIS request documentation of how one supported oneself during a period of unemployment. So this is a new thing, and I have started to see that because they want to know that you weren't already working for the new employer or in any other kind of unauthorized employment, which would negate the grace period being granted and your ability to transfer to a new employer via the change of status route. Also, if your new employer is a smaller company, maybe they haven't ever hired an H-1B worker or they have very few employees, you might want to wait for that approval to make sure that your new employer is going to be approved because we're also seeing a lot more scrutiny on things like the home office, that working from home, and where, nowadays, if you have a small company, everyone might be working from home, but we're starting to see a lot more scrutiny in those areas. Now that we're out of the pandemic, they want to know these are really legitimate offices, legitimate companies. And so you might want to wait for that approval before you actually cut ties with your former employer. The other big thing, and this is, all over the news, there's correct information and misinformation about this topic, but there are new AI tools and big data processing tools and capabilities that are bringing to light applicants' old ineligibilities, things like falsifying information on prior applications or immigration forms, or maybe an arrest that didn't result in a conviction. Applicants engaging in unauthorized work, employers flagged for past fraud, even 10 years ago or more. These types of things are being uncovered using these new tools. So, and I'm routinely hired for these kind of consultations for people who receive these denials or RFEs based on these kind of things. So I do know these things are happening and are being used to, for example, deny someone the grace period or deny a change of status or even a new H-1B application.
Yeah. Now, Attorney, Cap-exempt employers can provide alternative pathways. What type of employers qualify as Cap-exempt, and which professionals are most likely to benefit from these options?
Okay, so many people do think that Cap-exempt means nonprofit, and I've kind of had to burst the bubble of some people, unfortunately, because Cap-exempt and nonprofit are not the same thing. A nonprofit is not necessarily Cap-exempt. Cap-exempt is most typically an entity, a nonprofit entity that is a university or affiliated with a university or some type of research organization. All right. But even things like certain community colleges can qualify as Cap-exempt. It does not have to be a four-year university. Under certain circumstances, a community college can even qualify. And organizations affiliated with universities tend to be entities like hospitals and other schools, like even elementary and secondary schools that act as train teachers as part of their set curriculum. And also, like I said, various types of research organizations. And there are some more creative ways to use the Cap-exempt status. I'm not going to get into those, but there are some more creative ways that you can think about. And these are all, on the USCIS website. But what is important to know that Cap-exempt has to be documented as part of the application. So if you are going to pursue that, you'll have to provide, if it's an affiliated organization, you have to provide the documentation that it is affiliated with the university and that it is a nonprofit. The typical types of jobs are usually adjunct faculty. They could be tenure tracked, but tend to a lot of times be adjunct faculty, professional university staff, such as sometimes, graduate advisors or other types of advising type positions or professional admin positions, professional level medical workers, and as I mentioned before, elementary and secondary school teachers and research assistants.
All right. Now, when moving between Cap subject and Cap-exempt H-1B positions, how should employers and employees plan strategically to maintain compliance and flexibility?
Okay, so I would say, as an example, the most typical kind of scenario that I see is a student might obtain an adjunct teaching position after they graduate. That's maybe only 10 hours a week, sometimes even less. And on H-1B, that's totally fine. A position does not have to be full-time. And what that gives them is the flexibility to leverage that status to add a concurrent employer that would normally be subject to the cap in a conventional, traditional type of job. And because they have this concurrent employment, they don't need to enter the lottery to take that second job. The employer would have to file a petition, but they don't need to enter the lottery. Now, to maintain maximum flexibility, the student might, in the future, want to enter the lottery with their other employer, the non-Cap-exempt employer, and kind of do a switcheroo. Now, this costs money, of course. The new employer would have to be willing to pay the costs associated with this. But were that university job to go away, which usually those are just year-to-year contracts or semester-to-semester contracts, if that were to end, the person would at least be able to maintain their H-1B status. Now, you're still subject to the same limits, 6-year limits and everything else, but you wouldn't be stuck with no H-1B status and then, just taking your chances on the lottery. You could just keep trying the lottery even every year to just hedge your bets and try to ensure that you can maintain a status. Also, if you're an employer that does need a lot of H-1B workers, you might consider pursuing a university affiliation. It might be cost beneficial because of the current policies to figure out if you can make that work for you, if you are the type of entity that would qualify for that.
All right. So looking ahead, what practical planning advice would you offer professionals and employers seeking to build a long-term H-1B strategy that accounts for uncertainty, career shifts, and policy changes?
Well, the pool of H-1B workers really is going to shift largely to students and current H-1B workers. And the hiring of specialized workers directly from abroad is going to be cost prohibitive for most employers. Now, I would keep, if I were, an employer or somebody thinking about this, I would keep my eye on, the developments in these policies, because right now there is no real further elaboration of what kinds of workers might be exempt from this $100,000 fee, other than people who are eligible to change their status. And there is a national interest exception that was published, but it's still very nebulous as to who that is. It has not been codified, or there's been no elaboration as to who that will apply to, although myself and other attorneys have definitely submitted applicants as for this exception. And if you are an applicant with prior job experience in your home country coming to the U.S. for graduate education, you are likely in a better position to command that level 4 wage, because you're going to be have job experience, an advanced degree. You're going to greatly increase your chances of a lottery selection over somebody who's an undergraduate degree with no job experience. And so that's the pool of people that's going to be is probably going to shift around. The demographics, I think, are going to shift. And like I said, if you are an organization that has the possibility to develop that university affiliation, that may be, again, cost beneficial for you to start looking into how you may do that. Additionally, I am seeing a lot of employers now pursue the EB-2 green cards and EB-3 green cards for their workers sooner than later, just because of the uncertainty of the H-1B program, and trying to develop a pipeline of workers through those means rather than the H-1B temporary worker program.
Wow, what a truly interesting session it's been. Thank you for those insights, Attorney. For everyone watching, H-1B status requires ongoing planning, communication between the employer and the employee, and awareness of timing. Backup options, transfer rules, and Cap-Exempt opportunities can provide flexibility, but only when approached strategically and with a full understanding of compliance requirements. If this is your first time tuning in, welcome. ImmigrationQuestion.com is a networking platform where users can ask immigration-related questions at no cost and engage directly with participating attorneys. We're also proud to share that ImmigrationQuestion.com is BBB accredited and ISO certified, reflecting our commitment to transparency, accountability, community education, and security. Now, Attorney Johnson, based on your experience, how do platforms like ImmigrationQuestion.com help immigrants and immigration attorneys like yourself?
Well, as I mentioned before, there's a lot of misinformation out there. And a platform like ImmigrationQuestion.com, where the information is being vetted by attorneys who are actively practicing in immigration law, it can really cut through what's the information that's out there that is pure, gossip, may not be true at all, or just based on someone's personal situation where you may not be getting all the facts. So it is good to have these types of platforms where you can at least start your research and looking at things that might be options for you.
Thanks for those thoughts, Attorney. Now, before we move into our Q&A session, I have one more question. For professionals feeling pressure due to lottery uncertainty or pending employment changes, what warning signs should prompt them to slow down and reassess their H-1B strategy before making a move?
Well, they really need to be careful that because sometimes employers are also not very educated on the requirements either. And so really making sure that this position is going to be considered a specialized occupation, that can be a big mistake that can, because once you get in with one employer in the lottery, you kind of stuck, at least with that option. And if it turns out that it doesn't work out, or the employer can't prove that they can pay you, or things like that, it can be really devastating, especially if you're done with school and you've kind of closed off all your other options. So you really need to be careful that there are scams out there as well, and you really need to be careful that the employer you're working with is a bona fide employer and has a bona fide job.
If you've just joined us, we've been speaking with attorney Tiffney Johnson, Esquire, on H-1B survival and backup plans, cap rules, transfers, and cap-exempt employers. We are now moving into our live Q&A session. This is your opportunity to ask questions directly to a licensed immigration attorney. Please drop your questions in the chat or call us live at 516-703-3483, and we'll take as many as possible. All right. If my H-1B registration was not selected this year, what can I do next year to be selected?
Well, as I mentioned, with the weighting now, the weighted algorithm that is going to be selecting applicants now based on the wage level, giving applicants with a higher wage level a much higher chance of being selected. Of course, if you don't already have an advanced degree, you might pursue an advanced degree. Some advanced degrees, you can even complete in 1 year. So that might be an option for you to increase your chances, because I definitely can say that the advanced degree does give you a much better advantage. And then also looking for an employer that is willing to pay for your skill set. And if that means you need to get experience to make yourself competitive for those jobs, that might be what it means.
All right. What if I'm on OPT and didn't get selected in the H-1B lottery? What other options can I try?
Well, you can also if your employer really wants to keep you, you can start that conversation with your employer about green card options. Now, none of those have visas available right away, but there may be another type of another type of degree or certification you could pursue in the meantime in order to maintain that status. Of course, if you're eligible for STEM OPT, you want to go ahead and start that process as soon as you're eligible to start that process for extending your STEM OPT. But there are, you might even have, you just want to be careful, because with the H-1B, again, with that requirement to change status and not be out of the country as a brand new applicant, you want to be careful to try to maintain some type of status in the United States and work with an attorney to make sure it's an appropriate type of status.
Right. Is it possible to transfer my H-1B to a new employer without being counted under the cap again?
Yes. So typically when you transfer to a new employer, if you were already selected in the lottery as a cap subject H-1B, you are actually cap exempt. You're not subject to the cap under your new employer. So as long as you're within your 6 years, or you have the option to extend, you're in a situation where you're allowed to extend past the 6 years, you will not be counted under the cap again when you change employers. You don't need to enter the lottery again.
All right. If my current job ends, can I stay in the US while I wait for the next H-1B cycle?
So that's a very broad question, because that depends on a lot of factors. Typically, you have to be outside of the US for a period of time before you're eligible for another cycle of H-1B. And like I mentioned, because of the $100,000 fee, this is not a good idea for some people. So this is kind of a very individually specific question as to what your options might be and whether or not you would be eligible to do this. Because, like, for example, if you were in a cap exempt job, maybe this is an option for you. If you're within your it might be an option for you. This is a really kind of a specific question that would really depend on a person's individual circumstances.
Yeah, all right. I want to know if Cap-exempt employers like universities will also have to pay the $100,000 fee.
As of the current policy, if this were someone who was not eligible to change status in the United States, a Cap-exempt would have to pay the $100,000 fee. Now, typically universities are looking at their current pool of students when they are looking at people to hire into some of these positions. So they do have a pool of people who would be eligible, and it would be very rare unless it was somebody with a special background that they really needed on staff, I guess, that would allow them to pay the $100,000 fee. Yeah. But under the current policy, all employers have to pay it.
All right.
Mm-hmm.
Can my employer still file an H-1B transfer for me, even though the cap is closed?
I'm not really sure what that means, but if you have one employer, the whether or not the lottery is open doesn't have anything to do with your eligibility to transfer from one employer to the other, because you won't be counted in the lottery again. So you can do that regardless of whether it's the open season for H-1Bs or not.
All right. Now, attorney, recent reporting indicates that an appeals court has upheld the Trump administration's mandatory immigration detention policy. When employment-based visa holders follow developments like this, how should they understand the broader enforcement environment and its potential impact on status compliance and immigration planning?
Well, as I was mentioning before, that a lot of these new tools are being used to detect an applicant's non-compliance with the terms of their visas. This means students. I think that's probably the thing that is affecting most of the people that I see, is that they did something when they were a student that was not authorized on the student visa, such as unauthorized work, or even, I guess, the use of public benefits could possibly be used against someone in certain circumstances when they were trying to change their status or adjust their status. But it's the level of information that is available to immigration authorities has exponentially increased, and their ability to process that information has really improved. So if you are, for example, a student who had some kind of, a rowdy night out one night and you got arrested, but no charges were filed, they let you go. That could actually really harm you because those are the grounds for student visa revocations now. So you really have to be very cognizant of staying within the terms of the visa and, obeying U.S. laws while you're in the United States.
Yeah. Thank you so much, Attorney Tiffney Johnson, Esquire, for sharing your time and insight today. Your guidance helps professionals and employers better understand how to navigate the H-1B system with preparation and flexibility. And to everyone watching, thank you for joining us today. We hope this discussion provides clarity on cap rules, transfers, cap-exempt opportunities, and practical backup planning strategies. You can always visit immigrationquestion.com to ask immigration-related questions and stay informed about upcoming live discussions. If you'd like to revisit today's session or share it with others, the full replay will be available on Spotify. Just search Borderless Talk by immigrationquestion.com. Join us on Wednesday for another live conversation covering key immigration topics and current developments. Until next time, goodbye.